republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
This is the Preble Town Board meeting. This is a special meeting by the town of Preble that will be held Preble Town Hall, 1968 Preble Road, Preble, New York, on the 22nd day of July, 2024 at 7 p.m. to receive and review draft prepared by the Town Planning Board of short-term rental regulations and such other matters that may become before the board. Don, can you open us up with discussion on this?
What you have in front of you are actually two versions of the same proposed local law. The version that has the draft Preble local law number 2 of year 2024 regulations for short-term rental properties, and then it goes on to talk about prepared July 19 after 2 special meetings. Okay, so that's what the plan, that's a direct result of the planning board's efforts over the last 2 meetings as mentioned there. Now, if you compare that to what I just dropped off, and it says just simply local law number 2 of the year 2024, it's really in a local law format. The only change is that heading. And then if you go and compare the very end of those 2 versions, I'm going to refer to it as Peter's version, but it's really the planning board's version that Peter volunteered to put together, and was the word Smith and the preparer of that, ends at section 12. You'll see that on the other version, the local law version, if you will, there's a section 13, which I would refer to as somewhat boilerplate. And then there's a section 14, is there not? Yep, it talks about the effective date. Otherwise, the 2 are exactly the same. So, as far as the substance, there's pieces of this from various other sources, if you will, of short-term rental regulations, as well as the planning board members' own input and opinions and conclusions and consensus. And again, this is a standalone proposed local law, which we talked about at the last board meeting, and is submitted to the town board here today for consideration. I had a couple very minor kind of possible changes depending on what the board thinks. And remember too that the timeline for this is such that if this matter is going to be reviewed by the Cortland County Planning Board, which to enact any local law must be reviewed by the Cortland County Planning Board, which meets once a month. So their August 20 meeting is their August meeting. To get that on the agenda, this must be referred to the county planning department by this Friday, the 26th. If we were to do that and get it to them by the 26th, we make that August meeting, and that would allow this town board to then potentially act on this at its September meeting, unless of course there's some special meeting called by this board before that. But that's the timeline. And as we went over at the last board meeting, if we didn't get it in by the 26th, we lose the August meeting. Now we fall back to the September meeting. And that, because of our moratorium expiration date, cuts it pretty close. So I think this is in conformance with what the board had asked, this town board had asked for. And, I think it's a result of honest diligent, thorough effort by the planning board members.
Mhm. And of course, this does not have to be perfect tonight because we might get changes or additions or deletions um, from the county planning. And we also will have a public hearing and we can make changes then too. Right.
No, the public hearings after the county review.
Yes.
Well,
Um,
the public hearing would it depends on when you set it. But in the normal course of events, you might pass, if this format is acceptable to the board tonight, the two actions that you can take on tonight would be one, resolving to refer this to county planning, and two, to establish a public hearing. Typically, you'd have the public hearing at the next regular town board meeting, which would be August 12th and would be in advance of the planning board's
okay.
review. You don't have to, but you
Right.
could.
That's the way we normally do things. So we can certainly have a public hearing at our next board meeting on August 12th.
Jim, in terms of Jim,
Mm-hmm.
this Jim here, you could have the public hearing. You couldn't then enact it on August 12th because you haven't received the recommendations from county planning.
Mm-hmm.
So we would have to do a long form seeker too before you enact it.
And that would be at our September meeting, most
Right.
likely. Yeah.
Right.
Okay. Well, let me just ask the board. You've all read through this, maybe underlined it in red and highlighted it, whatever. Is there anything in here that anybody disagrees with? They want to add to it, they want to delete, they want to change, anything of that nature?
There's just one thing on a date that it's on there that the Preble local law on section 4 and under D, where it said Preble local law number 1 of the year 2024 is 122. That's when we approved it, but the state approved it on 129.
So it would be
But
changed.
I don't know if that has to change, but it was an intact in 129.
That's fine.
But that's just
That's great.
So we'll change that to 129.
Yep.
So that would be in,
So you
in
could-
section 3A too. The date is the same 122.
We might put in the parens effective 129/24.
Yeah, right.
How about
Mhm.
that?
Yeah.
We would change in section 3. Well, there's two places there
Yeah.
in section 3
Yeah.
Yeah.
that we would change that. And that would bring the deadline to this on October 29th, right, Don?
Yeah, that remains the same, I
Right.
believe. Yeah.
Okay.
Section 4C on the transfer of ownership. So does that mean it can't be, explain that section to me a little bit? Is it, it can't
The
be,
new owner would have to apply and get their own permit.
okay, so it can't be transferred through stock or corporation. Okay.
That's the effort.
Okay. Okay. Or LLC can't. Okay.
And as we talked about at the planning board meeting, and the nuanced view too is, okay, well, what if, you could, is it any transfer? In other words, if it's kind of a generational type of thing, so they transfer 10 shares out of 100 to a member of the family.
Mhm.
So, and also realistically, we talked about, well, how do you know? How will you know that occurs?
Mhm.
So that may be tough to enforce, but the idea is transfers of ownership, when a transfer is by a deed, public record is made pretty easy, it's pretty obvious.
Mhm.
But you can do transfer of ownership through transferring stock or membership interest, and that's not obvious. But the idea is that if it's still a transfer of ownership, then they, you know, the new owner should have to apply for a permit.
Plus, this permit will be renewed every 2 years.
Correct.
So if there is a transfer, it will be known at that time.
Good point.
Anybody else with anything?
Yeah, it's, section 5, number 5F. Who determines the rules of conduct?
Well, the way that's worded, it would be up to the owner.
Okay. So there's not going to be uniformity. There will be uniformity, or there
No,
won't be.
I agree with you. There
Yeah.
wouldn't necessarily be.
Let's see. Section 6, number 9. The question about vehicles and parking. I don't know how many bedrooms these things usually have, but one vehicle per bedroom seems like a lot. So if you got, there could be a lot of vehicles there.
Well, actually, I think that's a proposed limitation.
Right. So if there's 6 bedrooms, they could have 6 vehicles. Right.
If
But
there's,
I would
if there's
propose that
parking spaces suitable.
Yeah,
Mhm.
that limitation should maybe be less than that, but
You can, there's a rational basis to put some maximum number on, perhaps.
I mean, like I say, I don't know what the parking space around these, the ones that are currently being operated are. If there's adequate parking space there. Now, I don't know that, but
When it's defined as 9 feet by 20, yeah, is there, do they have to be individual parking spaces for that? Not just one driveway back to back? I don't know if that's more of a question for the code guy. Accessibility for the tenants. If there's 3 bedrooms and there's 3 cars and they're back to back, there's no defined spot for each one and they can't park on the grass. The first one can't get out without moving the other one. So I believe Peter is talking about having defined parking places. So each one can come off the road and get into at least a 9 by 20 spot, parking spot. Which would be more desired for the customer, I would think, or maybe more safer if somebody had to get out quick. One car would be blocking everybody else. So
I can't get into our code enforcement officer's head, and maybe we can add language that makes clear that that kind of arrangement does not constitute a parking space. In other words, you're suggesting, I think, that, if you have a driveway and they draw, 4 rectangles that meet the size in the driveway, but having done so, the deepest car can't get out unless the other 3 cars pull out.
mm-hmm.
If you're concerned that that's going to be regarded as a parking space, I think we could maybe refine this language and address that. But my reaction would be, I don't think that qualifies as a parking space. But if you wanted to add additional language that makes that type of arrangement explicit, I guess, I believe that's the intent of the planning board in putting that together. That doesn't, if you're driving over a space, you have to drive over a space. I'm not so sure that would qualify as a parking space, but without saying anything more. But if you want to add language that makes it further explicit, we probably could do that, right? I
Yeah,
mean,
I
that's
think
your
so.
point, right?
Yeah,
That
right,
should
that's my
not
point.
qualify as a parking space
All right.
arrangement.
Yeah.
Okay.
Well, could we put an asterisk on this and wait for county planning to, maybe they might notice something here regarding this and give a recommendation, so at least we can see if they do have a recommendation and then go from there.
Yeah, they may already have it all defined.
Yeah.
I would think.
Yeah, so let's just,
I mean, something like each space
Highlight this.
has the ability for ingress and egress without movement of any other parked vehicles or something like that. I would think we could come up with.
and then we have a limit of 12 people to a property. On number 10.
So on number 14 on that same section, the sign, so this sign is going to be posted out front inside a building, and it's just to let people that are coming in know that that's where they're supposed to go. Is that what the purpose of that is?
Where they're supposed to go, you mean so they can easily find the place?
Right.
I would think that would be one reason.
Okay. I mean, is there another reason for that should be in there? Guess I don't see.
Yeah, I
don't see.
don't know what
advantage
Peter
of
was
disadvantage.
thinking there. I don't know
Well,
if that's accessible or.
There is, the permit is to be displayed. I'm looking at section 8.2. I don't know if the intent is that should be on that sign as well, but certainly to locate the place.
In areas where we have noted the application to be submitted to the code enforcement officer, like section 5 and A, I think we should add or the submitted to the clerk or a zoning officer. If we ever have a helper for our code guy, it would be a zoning officer, because it could be any place where an application could be submitted, but it's not the code officer would make the determinations of what that was, but just to be able to submit the applications, or there's other areas in there where it says to contact the code enforcement officer to submit something, compliance, or there's a couple different areas.
So I'm sorry. So you're suggesting
So
what,
like,
Jim?
so what the application should be submitted to the code enforcement officer, but it's an application to be submitted. If he's not available, I mean, the clerk or
We're looking at section
zoning
5.
officer, section 5A
Okay.
there. If we have a helper for the code guy, if we ever appointed one, like a zoning officer
So how about if we added or other author,
officer, oh, I don't know, clerk wouldn't be an officer, but
or
I would,
other duly authorized town representative?
yeah, yeah.
You want that every place that
Yeah, there's other areas in
Presidents.
there you can,
and
Yeah.
B right above it. There's
there's some places that you can submit it, and other places he has to make a determination.
Well, the way this is drawn, the application is reviewed and decided upon by the code enforcement
Right.
officer.
Yeah, that's, should be that way, yeah. Yeah. Mhm.
Then in that same paragraph, talks about a non-refundable permit fee to be determined. So that would be the fee that would cover 2 years of time, right?
Yeah, it would be for a
Mhm.
2-year
Right.
permit.
And that's something the town board would have to decide would be appropriate and fair.
There's another place right there that's the same submitted permit, but another place in section 9.
Mhm.
I just thought it'd be more accessible for the people renting it out, that they could submit it. They wouldn't have to submit it to the code guy.
It's
if he's
not like they have to
available.
hand it to
Right.
Rick.
Right,
I mean, he
Yeah.
could have a box here
right,
Right.
to
right.
receive applications, but
Right.
that's,
Just
it may
accessibility.
But
be-
eventually it goes to Rick.
Yeah,
Yeah. Even if there's a helper that takes it or there's a box that receives it,
yeah, just
it's
to
gonna
make
go
it
to Rick.
easier to submit.
And then 7B. It says that the code enforcement officer is authorized to request permission to inspect the property.
Mhm.
And that in the section 8, the same language is in there. Is that so if there's a violation or and permission is denied, what happens then?
Well, actually, that, at 8A1,
Mm-hmm.
the second full line up from the end of that paragraph, to conduct an inspection for purposes of ensuring compliance with this law. In reviewing this afternoon, I wrote down and/or make appropriate application for a warrant to inspect the premises. So that would be the remedy.
Okay.
If permission is not given, if you can get a warrant issued, to inspect. So I think that might be appropriate to add that language.
Mhm. Okay. Anything more, Mike?
That's all I had.
Okay. Dave, anything? Do you like it or not like it? This document? Neutral? Okay.
So I had a couple particulars in taking the time to read through. So section 4 sub A says owners of any parcel wishing to use their property for short-term rental purposes must first apply for a revocable non-transferable. How about if we say apply for and obtain? Okay, to make clear that they must obtain
Mm-hmm.
before they can use. Okay, so I'm suggesting that apply for and obtain irrevocable be added. It's kind of common sense, and maybe it's overkill, but I don't think that can hurt.
That's 4A.
Correct.
Okay.
We mentioned the warrant, that's at 8A1, adding that language. And I've got noted what Jim's comment is, the 2 references to other duly authorized town rep on those 2 sections. And at section 9A3, just to, again, maybe a little bit overkill, but it says the procedure for applying for renewal of the conditional permit is the same as that specified in section 7 of this law. I think we might want to say instead of just section 7, perhaps say sections 5 through 7 of this law, because 5 and 6 are substantive. So it makes clear that those same requirements apply upon an application for a renewal. It's not, 7 is more procedural. So I'm suggesting, just a suggestion, that we might say sections 5 through 7. Also, I think at section 10A1, I think the word should be issued and not issues towards the end of that first line. Then the very last A2C of that section 10, and shall file a copy. This is the notice of revocation now it's referring to, and shall file a copy with the original application. The original language was with the town clerk. I guess the planning board wanted to lighten up the town clerk's obligations, but we might say original application located in the town's records. In other words, we should make and keep permanent records of applications. So I'm thinking that notice of revocation should be filed, just to make clear, with the original application located in the town's records. I don't think it changes it. I think it just makes it explicit. Again, another nitpicker at subparagraph B, penalties, actions by town board, right below, sub 1, third line down. Upon conviction thereof, be liable to a penalty or fine. How about if we say is subject to a fine of not more than $250? So rather than be liable for, I don't think that wording is great, but I don't think we're talking about a penalty. Ultimately, I think it's a fine. So thereof is subject to a fine of not more than.
And eliminate the 15 days in jail.
No, I didn't
Okay.
say that.
Okay.
Just remove the liable and the
Okay.
penalty.
Okay.
That would be something that would be a sentence imposed by your local justice court if it ever came to that. So that's really not a substantive change. That's more kind of a cleanup, clarification. Again, wording section 11, A7. I think it might read better if it says the code enforcement officer must provide a report of the suspension of the conditional permit to, and then rather than must file, because I think we're referring to that being provided to the various people and entities there. So must provide a report. And for language to be consistent, it's sub B following that third line where it says adjacent neighbors. I think we want to change neighbors to adjacent property owners. And again, 13 and 14 is kind of lawyer boilerplate, but that was added that wasn't included in the planning board. So if the board wants to authorize those changes, we could make those changes to this draft version.
Need a motion to make the changes Don just described.
I'll make a motion to make the changes as prescribed.
Second.
All in favor?
Aye.
Aye.
Carried. Okay, so we'll make those changes. We also need a motion to refer this to county planning. See what they have to say about it.
I'll make a motion to refer to county planning.
I'll second it.
All in favor?
Aye.
Carried. Now we need a motion to have a public hearing on August 12th, which is a Monday, which is a regular board meeting. And this public hearing would be at 7 o'clock and the board meeting would follow. Need a motion for that.
I'll make a motion to have a public hearing at our August 12th town board meeting. For the
At
purpose
7
of,
p.m.
at 7 p.m. Yes.
Need a second on that?
Second.
All in favor?
Aye.
Carried. Okay, so we'll refer this to county planning. We have a public hearing coming up. I just, any other comments that anybody has? Okay, I just want to say that we sent letters out to all property owners in the town last week. Some of you may receive them already. Just another item of business. We're looking for a landscaper to do the front of the building. And we're taking proposals for that. And I'm looking for people. And if anybody on the board here has somebody they can recommend, then that would be good too, to pass them on to me. Is there any other business that the board has that they want to bring up? Okay. So we'll open up the meeting to public comment and questions, but if your comment or question is very lengthy, please keep in mind that we will have a public hearing in 3 weeks. And you may want to save your ammunition for that, but please speak up and ask questions and provide comments. Anybody? Yes, yep.
Hello, my name is Brody.
Wait,
Smith.
I had Skip
Oh,
speaking,
sorry,
right behind you.
apologize.
That's okay.
I would just like to say that I'm concerned, it sounds like it's gonna cost the taxpayers a lot of money to enforce all this. And it seems like us taxpayers that live here are gonna pay for it. All these rules, you're gonna have the clerk's gotta do stuff. Mr. Fritz has gotta do a whole lot more, possibly put on another person. As a taxpayer, what the? I mean, it seems like we're subsidizing businesses. That's all I got to say.
Okay. Good point.
My name is Brody Smith. I've spoken to you before. I represent multiple property owners on the lake. And I'll try to be brief. I appreciate you giving us.
Excuse me, are the property owners neighborhood people living in their homes?
Yeah,
Or are they short-term rental people?
both. Yeah. So
Thank you.
they live, my clients, they live on the lake and they have rental properties directly next door to them that they rent out. So I'll try to be brief. There's 2 things that I think are big sort of legal concerns of mine, and then there's just a few sort of more minor things I just want to raise to your attention. The 2 big legal issues is first the non-transferability that you see in the law. And what Mr. Armstrong was saying a moment ago maybe part answers my question. The way that I originally read it, it seemed as though the ability to get a permit, just I think, as you read it without context, would end, right? Like if my clients died, their kids wouldn't be able to be a prior existing use. So that's not the intention.
Not the reading.
And it's just that they need to reapply for a new permit. There's really no objection to that. But as I read it, that might be something that would be sharpened with some language saying that, you'll still be a prior existing use. You'll still be able to apply. You'll still be in that
I understand,
category.
but
of
it
the
doesn't
lake
say,
property
it
owners.
doesn't. So
Yeah.
that's certainly the intent, Brody.
Yeah.
That a new buyer has got to get a new application.
Right.
That's clearly the intent.
But there's still a prior existing use and they still could.
That's correct.
Yeah, because in the
That's
Lake
correct.
District, the only people who can apply are people who are
You got
prior
it.
existing uses.
That's correct.
So we'd request just some clarification there, and that's good to hear. The second big one is, from a legal point of view, I really do think that the enforcement provision is a due process concern. This is section 11. Generally speaking, codes officers, there's sort of like there's a flow chart of what your options are. You get a complaint, you investigate, then you got 2 choices. You could issue an NOV directly to the property owner, kind of hoping that they fix it, or you could issue a ticket and they go to justice court and the fines and the jail come into play. Usually when you issue an NOV, people will correct it. If they correct it, fine, it's over. If they don't correct it, then the codes officer either follows through issuing a citation, or that you can have your day in court essentially at the ZBA and contest the NOV and say I disagree with the issuance of the notice of violation. Right. This, as it is, doesn't quite have that. If you read section 11, it says the code officer may immediately suspend the permit, and then it gives a list of things. And one of the things is any conduct on the premises, and it lists a bunch of things, including that disturbs the peace. So if you think about, this is a real estate asset. These houses are worth hundreds of thousands of dollars. If one person complains, no one's been convicted of anything. Nothing's been proved. You haven't had a chance to give testimony. You haven't had your day of court. If one person complains, the codes officer can unilaterally suspend a
I'm
permit.
sorry.
Yeah. No,
We have a public hearing scheduled in 3 weeks.
Yeah.
Mr. Doring said, brief comments tonight. Tonight is not the public hearing night. I appreciate your comments. The legal matter, that's fine. But now the next person should have just as much time as you're taking to make comments if they so choose. How does Mr. Doring cut someone else off? And again, are we going to go over the same groundwork 3 weeks from now at our public hearing? So I'm out of line, and I'm sorry. So Brody, I interrupted you. You have the floor. So
Okay, Brody, finish your thought.
Oh, that's okay. No, I appreciate, what Mr. Armstrong's saying is true. There's going to be a public hearing soon.
Yeah.
On that note, I would respectfully request that the board consider keeping that open in September. August is tough. Everyone's on vacation. I'm on vacation on the 12th. That's a tough time. That's a tough time to have the public hearing. Also, I feel like it makes more sense to have the public hearing after get the county.
Mr.
comments
Smith,
too.
we have done, this is a special board meeting tonight. These are working people in here tonight. The planning board has met time after time after time, special meetings to get this ready. Okay, so I appreciate your comment. August, you have vacation, but this town has tried to do its diligence in putting this together. They really have. The board, we were here last Wednesday till 10 after 9, starting at 7. We met the week before. So I appreciate your comments, but boy, in the context of things, and we can't enact it on August 20 either.
Right.
You know that.
Yeah.
We can't enact it. So it's going to come up at either a special board meeting thereafter or the regular board
Yeah,
meeting.
that's
in
all I'm saying.
September.
I just ask you keep it open.
yeah.
That not be the only public hearing.
I got you.
That's all I'm saying.
Yeah, that's
Okay.
fine.
So-
Anything else? Yeah, go ahead.
Oh, I don't interrupt you.
You have something brief?
Yeah.
Mike?
Very briefly, I'll just say the idea of the sign where you have to put your phone number on it. Obviously, you've heard before, no one really likes the idea of having to put the phone number on the sign in the front yard. I think you want complaints to go to the codes officer, not to put property owner's phone number on the sign. Also, the trash cans, I would just ask you to reconsider this. This is an illegal objection, it's a practical thing. It says you got to store the trash cans where no one can see them. I drove in the street today. Where these houses are mostly like situated, you'd have to hide them behind the house facing the lake. I'm not sure people are going to like that more. So I would just ask you.
I can tell you that we debated that at the
Yeah.
planning board. Okay.
Yeah.
That's been a matter of debate. Yep.
Yeah. So I get that, why that might be something to. And then the final thing is, my client, for example, sitting to my right, it's a 1-bedroom rental. It's common that like a husband and wife will show up in 2 different cars from work. So I understand you not wanting there being 20 cars there, setting a cap, but I do think like for 1-bedrooms, the 1 car limit's kind of rough, maybe not necessary. It would be disruptive to people.
Yeah, because there's 3 or 4 cars there sometimes, so in the 1-bedroom.
Yeah. So if you
Show
want to
up
say, I
during
don't
the
want to see
night.
6 cars there.
Show up during the night, you
There.
get 2 more cars there.
Yeah. So
So you gotta have room for them.
I just think it's,
So suggesting more than 1 per bedroom.
or like set a cap, like we don't want to see 6, 10, 12 cars. We want to see parties. Absolutely agreed. But if like 2 people want to drive separately to a 1-bedroom house for vacation, I don't really see what's so bad about that. It's very common that houses have 2 cars in the driveway. So that's all. Sorry if I was disruptive. I apologize if I antagonized you.
Brody, I apologize too.
Okay.
Right.
Anybody else? Yes?
Yeah, this bill is brought up to taxpayers paying. Let me tell you, as a taxpayer on the lake, I'm paying plenty. And if you guys choose to make a lot of rules, I don't need to pay. I don't mind paying for this enforcement of the rules that you guys are adopting on top of a bunch of rules. I don't need to, I've already paid plenty for my property. We're talking over the past 20 years, I've probably paid $250,000, and I'm gonna pay another $250 in the next 20 years. And if that's not, don't make any more rules if you gotta raise my taxes or whatever. What I'm saying is, I'm already paying plenty. As a business owner and a homeowner, I'm paying plenty. And there's concern about families on the lake. If you want families on the lake, cut the taxes on the lake. The problem is, I get a notice about every year which says we're raising taxes 8% on everybody in the town, but 15% on the lake owners, okay? And the reason I have an Airbnb is to help me pay the GD taxes, okay? That's why I have an Airbnb. Not to become a billionaire, but to pay my taxes. And I've paid plenty. And if the town wants to enact a rule, well, they can pay for the rules because I'm paying plenty as it is.
Anybody else?
Plenty of taxes. And if you put the rules on me, I don't need to pay any more, nor does anybody else. Don't make the rules. It's simple. You know, we're supposed to be a low government situation, but, you know, everybody wants to pile more rules. I don't need any more rules. We haven't had any complaints about our Airbnb. Families come to our Airbnb. We don't have parties. We don't have dogs. We don't have boats on the lake. We have limits on how many people can come there. So none of this is necessary for me to change my behavior.
Pete?
Never mind.
Okay. Anybody else? Yes?
I also live next to a couple Airbnb. Parking is an issue. If you could have designated parking where their lights don't shine on my house, my neighbor's house, people come in at night, they leave at 4 o'clock in the morning, they start their cars, doors closed. So I think parking is a serious problem. 3 cars lined up in a driveway is 3 cars parked in a driveway, whether they're designated a parking place or not, they're parked there. So that's easy. And 12 is the limit. Man, I was close to that all week with 12 people in the Airbnb. Cars are 5. Not a problem because there's 5 bedrooms. So these people live next to them, they own them, they got one car parked. Well, why don't you live next to me? I've got 5 bedrooms.
Please keep your comments addressed to the
He's-
board.
He's applied to redo another building for 4 or 5 more bedrooms. The house next to that has 5 bedrooms. So parking, 5 cars or 2 cars to a bedroom. Depends on where you live. Depends on how it affects you personally. Trash, sure, nobody cares until it affects them. 2 rentals in a row fill the trash cans. They don't get them out on designated trash night, like last night to pick up today. So I got trash bags outside the trash cans. And when are they going to get picked up? They don't have adequate trash for all the bedrooms, if that's what you go by. You gotta have trash in the can, not piled up next to it. The house cleaner didn't come yesterday, so the trash didn't get out. It's out in front now. Boats, well, they're carrying on boats. I don't know if people rent them with no boats allowed, but they come in with their kayaks and canoes, as they should, because they're renting, they're going on the lake, they're having a party. But yeah, there's boats. And I believe I was out of town on vacation in July, imagine that. And the cops came because somebody reported a body in the lake. So what is that? They go to the renters and say, and who's here? I was not there. I was only told by my neighbors because I was out of town. So we already had a reported drowning or body in the water. that was told to me.
The body in the water was reported by a Girl Scout camper, and it was never substantiated, and had nothing to do, as far as we know, with any Airbnbs.
Well,
Okay.
great, but it doesn't mean it won't be. Just
It
like,
can happen with residents.
that's right.
Please, guys, direct,
Things happen. I'm
direct to
sorry.
the, direct your comments to
I'm
the
just
board,
stating
please.
things. Now, that could have been a runner that got drowned and reported. I'm just stating what happened. Somebody reported it, or doesn't matter who. Things are happening. A lot more people. A lot more people.
Any other comments or questions? Okay, there's no other questions, then, any other business before the board, by the board members? Anything anyone wants to say? Okay, so if we have nothing more to discuss, then we need a motion to adjourn.
Before you do, my effort will be to make those changes, get them to Jennifer tomorrow,
Okay,
get them emailed to all of you, and so get it posted on the website. So it's hopefully within 24 hours, that's done.
okay, so the next time we meet will be August 12th at our public hearing. That'll be in 3 weeks. So we need a motion to adjourn.
Make a motion to adjourn. I'll second it.
All in favor?
Aye.
Carried. Adjourn.
It's not you, it's not you.
Long day, 7 o'clock. It's fine.
Me too.
Do you have an interest to talk to me? Stay and talk to you.
Yeah, I'm good.
You want to go to the hall?
All
Yeah. So they gotta go.
right, see you guys.
I'm just wondering. Plus they're saying that
Hi, I don't know
One guy who lives on the 11th, he's on the special landscaper, and he's somebody who did. Now, so we used to have a garden club. Older ladies.
Waited on the
Those ladies are in their 70s, 80s now. They don't want to do it. So we have more of this meeting.
So, you know,
Somebody takes care of this part.
we all have our.
What are you proposing?
But, so it was. You know, it's just. We had to change that. And we came back. She was so.
Well, I guess so. All of that was done as of now. You know, if you're still on your trip, I'm not. But like I said, you anyway.
Yeah.
And it's so bad, you guys will learn.
I'm so sorry. As far as that.
Well, we have people that are bidding for this, just do this professionally. And I guess it's important to have to decide, do we want someone who's sort of volunteering, with something whatever we can give you, or do we want, because when we have volunteers, we can't really tell them what to do. If we have somebody working for us under a contract, we can tell them what to do. So that's the difference.
So I did go around the building. I met with Sam.
Well, I don't like him anymore.
Yeah. Well, here, I'm sorry. I don't know her very well. I also grew up
See you in a couple
here.
days.
Couple
days, maybe.
Yeah.
Oh, what do you mean, maybe?
No, I'm
Calling
not.
sick?
These other ones.
Planning board meeting, right?
Oh, already?
24th. I am.
I've got so much, I got too many,
So,
too many.
unfortunately,
when I don't write it down,
it's just since we got
Hi, how are you? Good, good, good. Okay, I'll see you later.
I'll see you there, which is also why I have this summer off.
Well, I'll tell you right now, if we keep,